And this is the Westminster Standard Podcast. I'm Ryan Beasy. Welcome. Today we are having another special General Assembly process preview, looking particularly at the overtures related to adjusting the process. Just as last week we considered overtures related to our form of government, now largely overtures related to the form of government for the rules of discipline, though we'll dip into other areas as well. And there goes Steve Tipton, but I think I can bring him back. He shall appear. There he is. Welcome back, Steve Tipton, the nominating committee nominee for Standing Judicial Commission. Welcome. Teaching elder Jason Piland, welcome. You are the clerk of the Ohio Presbytery.
That is exactly right. Ohio.
The Ohio, yes. So some people don't think Ohio exists. We've had that discussion on this podcast already. Here you are, also a member of the Committee on Constitutional Business.
Correct.
Teaching elder Tipton O'Neill, member of New Jersey Presbytery. We are so glad to have you here, and I'm so embarrassed that I just did that.
Yeah, that's how we all say it. That's how we're required to say it by law.
As you're having your gas pumped for you, I understand.
Amen, brother. Best
all right.
Union.
Yes, you may not pump your own gas, but you do pump the iron, I see. And teaching elder Joshua Walker, former moderator of the Arizona Presbytery. Welcome, sir. First-time guest.
Current moderator.
You are currently the moderator. Well, I feel like you were moderator like 3 years ago. So you're not giving up that gavel, I see. Well done,
Correct.
brother.
Thank you. Thanks for having me.
Well, thanks for being here. So we talked about last week some of the SJC decisions of note. We have at least 3 members of the RPR committee from General Assembly here. Are y'all pleased with the way that Metro New York decision was handled? The mod father's not here, so you can talk freely.
I haven't really looked at the SJC's decision. I know we'll discuss it at RPR next week, so been kind of buried in other things, but I'm sure we'll have a chance to discuss and see what we want to recommend to the Assembly.
Yes. So let's dive in. We have 50 overtures this year to consider. That's a lot. And the deadline as of this recording is not quite upon us, so there may still be a 51st overture which might deal with space aliens. So I think that would be very fitting if, I think it's Southwest Florida Presbytery rejected that, but if the session that authored it sends it up, that would be Overture 51, dealing with space aliens. I don't know if we'll get to discuss that today, but let's start out with one about assistant pastors. I happen to like this overture, at least in principle. What are your thoughts on this overture? Overture 10.
Well, I've heard a lot of discussion about this, and lots of illuminating articles have been written over the last year talking about this, and it's become something of an issue that I've seen a number of people very animated on and excited about. Seeing that the assistant pastor is not consistent with our polity. And I think the overture points out some of these major points that people raise, saying that it's inconsistent with preliminary principle 6, where it says the power to elect persons to the exercise of authority in any particular society resides in that society, and saying it's inconsistent for an assistant pastor called by a session, not the congregation. It's inconsistent for them to be a pastor at that church with preliminary principle 6. And then the other one is cited in here. I'm having trouble finding it at the moment. Where talking about the consent of the governed is required, and because assistant pastors do not have consent of the governed, they should not be able to be a pastor in a church, and I have some sympathy with that. But I think overall, I want to defend the assistant role actually, and everybody who's been an assistant, well, I shouldn't say everybody, but most people who've been an assistant don't like it because they want to be on the session, and I count myself as one of those. My first call was an assistant call. But I think there's something, I don't think it's inconsistent with our preliminary principle 6 and with our BCO to have the role, because simply they are not governing. simply they do not have that authority in the church. When the senior pastor can't preach, who fills the pulpit? Well, the session is called in the BCO to fill the pulpit and to make sure that only qualified men are preaching. The congregation doesn't have a say who's filling the pulpit. It's the session who does that. And I think the assistant is really filling those roles where the session is called to shepherd and care for the flock. Maybe they want to hire a non-ordained person to run the youth group, but maybe they want to hire an ordained person who has additional credentials, who can help with preaching and administering the sacraments when the senior pastor is gone. So I think it's simply the session exercising its authority by calling somebody to help them, to assist them in their ministry and shepherding and caring for the flock. So, but I do think this requires an assistant pastor to understand his call differently from an associate pastor. And I think oftentimes in practice, we don't make that distinction. An assistant not seeing himself as supporting and being underneath the session and their ministry in the church. So I don't see the pressing need to get rid of the assistant pastor. I do think it can be abused, and I'm fine with putting a time limit on it, like Overture 10 is trying to do. But I don't see the problems principially with the assistant role. So and the way this one's written, I'm not a favor of Overture 10. So sorry about that lengthy argument there, but I'm curious what others might say to that.
I do find it odd that it has a 3/4 vote to keep going. Had they called him originally as an associate, he only would have needed a majority vote. But going this route now, this gentleman would need a 3/4 vote. That seems odd at best, I think. I'm not sure what the rationale or reason behind that is.
Yeah.
Well, it seems like it might be related to how an associate, a pastor on staff being elevated to senior status, that requires more than just a majority. So it's probably mirroring that in some measure, so that the congregation, out of obligation, doesn't vote for someone they maybe don't actually want. And so the overture really wants the congregation to be sure about elevating the man from associate or from assistant to associate in a manner similar to making a senior pastor.
Yeah. I think, I know I said this the last time we were on, Ryan, a number of times, but this also seems like a solution in search of a problem. I don't see the major issue, pressing issue in the PCA. And I agree with what Jason said. They don't rule. I mean, the consent of the governed, they exercise no governing rule over the people. And I appreciated his further comments just in terms of preaching. I mean, a licentiate could preach regularly in that church, and that's not. I mean, he's not even ordained yet, theoretically. I mean, and he could preach regularly if they wanted him to. So I have not. I mean, certainly I have seen instances where I guess what you would call assistant pastors or pastoral relations, we'll just say, in a church being bad, right? Things go bad. Assistant pastor does some things he shouldn't do, or maybe the senior pastor did some things to the assistant, whatever it is. But that's not this issue, right? Those are pastoral problems that are not solved by what this overture is seeking to do. It just seems to say, we don't like the idea of assistant pastors in our polity, so rather than just try to get rid of it altogether, which would have its own issues, we're going to institute this process which forces them one direction or the other. And I know it was CCB's comment on it, and other people who've commented on overtures have said it too, but I mean, one of the problems is it doesn't tell you what's going to happen to current assistant pastors. Are they grandfathered in? Are they not? I mean, I don't know. So, I mean, there are a lot of problems with this, and I just don't see, even reading through the whereases, reading through a lot of the material that's come out on it, I just personally don't see the need for it.
Yeah, as someone opposed to assistant pastors generally, I would like to see. I like the thought behind it, but I do see a use for assistant pastors, church planting. An assistant pastor church planting, I think, is, or an older man who wants to be part-time at a church doing visits, I think would be a great way to utilize assistant pastors. But I like the way my presbytery, by custom, uses assistant pastors, and that for the most part, they'll be an assistant pastor for 3 to 5 years, and then they'll be called as an associate pastor. I think that's the way. If we're going to have this in our book, I think that's the way to do it. I don't know that this is the fix that we need. But
well, if I could just say one more thing, Ryan. I mean,
please.
I know you want to move on, but the other issue is, like, if you're a pastor in a church or a session and you don't like assistant pastors, guess what? You don't have to call anybody as an assistant pastor ever. You're never going to be forced to do this. So this is almost like, I don't like assistant pastors, therefore I'm going to create something where you can't call them for longer than 5 years, even if there's a really good reason, or you think it's a good reason, or you want to do it. That's the issue as well, is that no one's being forced to call assistant pastors.
Yeah. And then why not, if you got to have a congregational meeting, why not just call them an associate at that point, which that may be the goal. And I don't want to go to their motives, but I'm not imputing ill to them. That may be the goal. It's so hard to make it and stay as an assistant pastor for that 6th year. Let's just make them an associate.
And I think that's right. I think that's what it's trying to do. But I think it also has an escape valve if the congregation is saying, no, we certainly don't want this man on the session, but we're happy to have him around with our youth or with visitations or something like that. We're happy to have him do that. 3/4 will approve that as long as he's not on the session. So I think it is an escape valve for those kinds of situations where they really don't want a man on the session, but they're happy to have him minister in other ways in the congregation.
Yeah. Yes, that's a great point. Well, let's reprise again, now that we are into the process overtures. We talked about this again, last week, Overture 1. As I said last week, and I think, Steve, you were the only one. You're the only person for repeat punishment. Appreciate you being on 2 weeks in a row, by the way. I was initially very much in favor of this. Now, not so much. What do y'all think about Overture 1?
Yeah, I don't have much to add other than beyond what you guys talked about in last episode. I thought they covered it well, and I think this just muddies the water with different levels of standard of proof required to bring a charge, and this seems to want to get rid of the voluntary prosecutor altogether, which I think is pretty essential in our process. So I'm not a fan.
Yeah, that is something. At least it didn't occur to me last week that this would do away with the voluntary prosecutor, wouldn't it? Which is always, when there are these disagreements where he did this and I don't think he should have. Well, it's not chargeable, but I think it should be. Okay, well then you bring charges.
That's right.
We wouldn't have that. Now you just got your hands tied.
Right.
Yeah.
And then that's Matthew 18 not being permitted to take place, and the church will not hear it. Exactly. That's right. That's
a great point. What about Overture 7 from Missouri Presbytery, sort of trying to come back at that threshold modification of how to assume original jurisdiction as well as invite other observers into presbyteries? Is that kind of a compromise with synodical level oversight? What do you think?
Well, I'll jump in again, seeing none others. But I think the piece about the first sentence, the process may include teaching or ruling elders from other presbyteries as non-voting advisors. I think that's entirely superfluous and ought to be stricken if this is going to go forward, because you can do that anyway. You can always bring non-voting advisors in any situation. And then I think grammatically it messes things up, because it's saying process may include a teaching or ruling elder, which is not grammatically what it's talking about in the first phrase of the sentence. So I think it's just a confused sentence. I get what they're trying to do. They're trying to succinctly add this phrase in there, but I just think it messes with the sentence too much. Because you can do this anyway. You can bring in other advisors in any situation. Yeah. And so this is just superfluous completely. So for me, I'm focusing on the second part of this, where it's changing that threshold from 2 presbyteries to 5, but then changing the ability for the other presbyteries to get involved from this refuse to act standard to this fail to uphold the Constitution standard. So that's really interesting. And I'll quit talking, let others comment on that piece.
How do you define fail to uphold the Constitution? Isn't that something that has to be determined by an external, by a third party, by a greater court?
I think the issue with the failure to uphold the Constitution, so I'm not a fan of this as it currently appears, failure to uphold the Constitution in a doctrinal case can mean, a presbytery investigated a man and found that his views, which, other presbyteries think should have been found unacceptable, are in fact acceptable. So it could be sort of that version, that they failed to uphold the doctrine of the church. But fail to uphold the Constitution could mean that they, slightly went against some procedure with respect to a trial, as opposed to them, having the charge read at the second meeting and, only doing like the enumerated things at the first meeting. They, shortened things and did things too quickly. Can two presbyteries, if there's an error of process, which is a violation of the Constitution, or five presbyteries, can five presbyteries basically force the GA to assume original jurisdiction over something that probably would be best handled by complaint? This seems a little bit too broad. I liked the overture from a few years ago, which I believe the language was, if the presbytery fails to indict. Mm-hmm. So it assumes that either they did an investigation and found no strong presumption of guilt, and other presbyteries think there should have been strong presumption of guilt. Then there would have been, the possibility of action under 34.1. So I think this is too broad as it currently stands. And what was offered, I think it was Fred Greco a few years ago, was a bit better.
Well, we would expect better from our mod father, wouldn't we?
Yeah, I appreciate the rationale trying to wrestle with what the trigger is. Is it failure to investigate, failure to indict, failure to discipline, failure to convict? I appreciate how they wrestled through that and explained their thinking a little bit, but I agree that I think indict really is the best trigger here for when this provision should be implemented. So I agree. I'm not a fan of that writing. Although I do think there needs to be a better standard than what's in our BCO right now, because nobody knows what it means to refuse to act, and that's impossible to invoke at this point in time.
Yeah. Do you think Overtures is going to have the patience to try to sort this one out, or is it going to be refer it back and come back with a superior version next year? But thanks for trying.
Well, I think the biggest problem that Overtures is going to have is that they have an enormous amount of work ahead of them. So getting into the weeds and details on something like this, unless someone's going to bring a updated version from the very beginning and try to move it as a substitute early that's well thought out, to try to wordsmith something like this on the fly is very difficult. So no, I don't imagine them having a lot of patience to work through something like this.
And I also think it's worth noting this comes from Missouri, where they were subject to others trying to implement 34.1, invoke 34.1 with regard to a case in their presbytery a couple of years ago. And I think it's encouraging to see them bring this up, to say, yeah, we want clarity in our process so that we all know what the right process is. So I applaud them. I'm grateful for their intent and then bringing this.
Yeah, that really, Missouri is my home state, and I'm thankful that I think it shows a lot of integrity that they're trying to work with the rest of the denomination.
Yep.
Yeah, thank you.
Before we move on, as my presbytery's representative to Overtures this year, I'm wondering, what would we think if the failed to uphold the Constitution language was simply just pulled out of this one, and the failed to indict language was inserted into this one?
Would that be an easy fix?
Yeah, it depends. What do people think of the change from 2 presbyteries up to 5 presbyteries? Because that's a substantive change as well.
Yeah, I think that's a good change. Kind of a compromise. I think, what was it, 10% that the mod father suggested, and now 5.
Yeah. Well, yeah, I think either way, right? I mean, there's no point having a provision in the BCO that, because of the way it's worded, can never be, you can never use it, right? I mean, Sure, we have this pretend, I guess, or potential escape valve if there's a case where, teaching elder is doing horrible things and his presbytery refuses to do something, or I guess refuses to do anything and fails to act. But we've seen these things come up before. We've also seen them fail, whether on overtures, on the floor, or even at presbyteries. So I don't know that this is, the year to try to do something like this, or to try to do it, especially at Overtures, where there's just a greater risk of like the unintentional change that, oh, that's not quite what we meant, or whatever else. So I would almost just say, give it back, or just say no. I mean, because really, no and handing it back are basically the same thing. I mean, you could bring it again next year if you wanted, even if you voted no this year. So
I'd say my slight pushback to that, Steve, would be that I think things have changed substantively since this was last brought a few years ago. This issue has cooled way off. There's no person that everybody's thinking of when this matter now comes up.
Sure.
And so I think we're in a better place to wrestle with this more abstractly instead of concretely trying to apply it to a particular situation we have in our mind. So I think it's better now. Maybe a year or two from now is better than even now. But I think we're in a better place to handle it today than we were a couple of years ago when it came up before.
That's fair.
That's a really great point. Let's move.
Given
Go
that
ahead.
it's coming from Missouri. So
Exactly. That's right.
Exactly
right. Agreed.
Okay.
What about Overture 14, just adding a little bit of language to 38.1? Is this necessary?
I think where this comes from is a desire when these cases come up, and this is brand new language from last year's GA, this whole paragraph regarding informing the offended person when somebody comes as their own accuser, informing the offended person, letting them see the confession, letting them provide comment on it. This is brand new. This is less than a year old. And I think immediately, as soon as it was started to be put in use last June after it was ratified by GA, sessions and presbyteries began to wrestle with, okay, how do we actually implement this? And one of the hangups is it requires the court to inform the offended person. And the question is, who can act on behalf of the court when this case comes up? Let's say for a presbytery that meets only a few times a year, and maybe you have a called meeting to receive a 38.1 confession. The court would then have to meet, and then it would have to say, well, now let's ask the offended person to provide comment. Technically, you can't do that before the court meets because the court has to inform the person unless there's bylaws or some other authorization that allows the moderator to do that. And so I think what happens in these situations is the court feels like they're bound by the letter of 38.1, which I think they're right. We are bound by the letter. And so they feel uneasy sending a moderator or anybody, a member of the shepherding committee, to talk with this kind of person prior to the meeting of the presbytery. And so I think what this is just trying to do is let presbyteries relax a little bit and not worry about those details and say, yes, the moderator can on his own do this. The court doesn't have to order the confession to be sent to the offended person so that they can get their statement back. So I think there's a good reason here when you're trying to work through the new 38.1. I don't know if it's absolutely necessary. Maybe someone could say by implication the moderator could do this anyway. Certainly if bylaws permit him, he could do that. I'm not against this because I think it does provide us letter of the law people a little bit more leeway. And when under the letter of 38.1, you don't have that. So I could take it or leave it, but I lean towards liking it.
I'll take that as a speech in favor.
We always want to give the Pharisees more letters of laws to make them more comfortable. Is there a Sadducee here who would like to speak against?
It's hard to take the moderator.
I'm sad, you see, because
yeah. I have a little pushback. Perhaps maybe you could tell me why my pushback is not good. As the current moderator of our presbytery, it seems that if this change were to come into place, this kind of gives the moderator unilateral discretion on this. And as the moderator, I don't always like that. I like the body being able to speak, the court being able to hear its voice in what they want to do. So how do you wrestle through that?
No, I love that point, and I am absolutely in favor of not having popes and bishops. And I think doing that kind of thing can tend towards putting the moderator too much on a platform. So I agree with that. I think the best way to address this is for a presbytery and its bylaws to address this situation and to empower a shepherding committee to do that kind of work prior to a meeting of presbytery. So I think that's the best way to implement that court action or that court language and allow the court to delegate that to a committee acting as a commission in this capacity prior to the 38.1 confession coming before the court as a whole. So I agree. I think this is not the best. So you're making me rethink myself on that.
Well, and I think two other pieces. I mean, it doesn't really address a presbytery utilizing a judicial commission
Yes.
for this. So, like, you're not a moderator at a commission. I mean, you're the chairman of a commission, perhaps, but then this language, do you need to go back to the moderator of Presbytery, who may not be and probably isn't a member of the commission? That's one thing. The other is, I mean, generally speaking, if there is communication from a court, it goes through the stated clerk. I mean, that's one of the responsibilities of a stated clerk is to provide communication. So,
Say what?
even apart from this, I would read this to say, if the court is supposed to communicate with somebody, Mr. Clerk, you need to take care of that. I mean, that's how, as the moderator of my presbytery, that's how I would handle those, mainly because I don't want to do it. No. But I would say to him, like, I mean, that's a communication thing to me. So I get what Jason is saying in the sense that, and it may even be that there's another problem, unintended problem from last year with the changes to 38.1 in general, because if a man comes to Presbytery, at the January stated meeting, let's say, and stands up and says, "Brothers, I have something I want to confess. Here's my written statement. I'm coming forward to the 38.1." Well, the way it works right now, at least as my understanding is, I mean, the court couldn't do anything until they communicate with the victim or whatever. And even then, you think about the double danger of that, right? Where the person who comes forth and confesses his sin confesses it in such a way as to, hide the fact that there even are victims. I mean, that's one of the things that the changes to 38.1 has talked about.
Mm.
But how would you ever even know just purely on the basis of someone's confession? And so I understand what we were trying to do, and I'm entirely behind the changes from last year. But I think in hindsight and in practice, perhaps there were just some gaps and some holes in how it actually is going to function, how we put that into practice in our presbyteries or in our sessions even. So I don't think this gets to that. It gets to a piece of it, but I don't think it's a piece that was really ever a problem, in my mind anyway.
And
Another solution in search of a problem, perhaps.
yeah, and I think that as I've tried to, I've talked with some courts about the new 38.1 and trying to walk through it with them. There is the question of, okay, the offended party comes back with a different story from the confessor and wants to include 10 different sins that the confessor only brings 2. And how do you litigate that when you don't have process? And so it's almost like immediately you have to, maybe you do have to go to process, but it's really difficult when the offended party says, no, he needs to say these 5 things. And the court's like, well, we don't know. Now we're weighing testimony without having rights of cross-examination. So now that we're allowing other voices to come in, it just is really difficult. It can get really messy really quickly. But I agree with what Steve said. I think it was good and right to make the change. I think we're just dealing with some unintended consequences.
So could the court in that situation, you take the confession, the written confession of the confessor to the person against whom she has sinned, and he says, well, yeah, but also this, that, and the other thing. Can you then take that back to the confessor and say to her, hey, would you add, what do you think about this?
That's right. And I think that's what it's designed to do. But then the confessor can say, well, that's not right. Those aren't true. I didn't do that.
Yeah.
Right.
And then you would have to go to process.
Mm-hmm.
But you could short step that. Or the court could say, well, there's only one witness to that anyway.
Exactly.
We're going to go with what we have.
Right. And that's right. That's right. Yes. And my view too is if a confession is of 2 sins, it's talking about a period of time, and I'm confessing to 2 sins during that period of time. If there were 8 other sins, that confession of the 2 sins doesn't cover the 8 other ones, and so you can still go back and do process for those 8 sins that weren't mentioned in the confession. So it doesn't preclude that in this process. So I don't know. It has become very messy. And I'm not sure it was intended to be that way.
Yeah, I think one of the objections Steve brought up, I wanted to respond to about if this doesn't speak to a commission. I do think perhaps it's attempting to when it does say or his designee, so that the moderator could appoint the chair of the commission perhaps as his designee in this situation. So that may be what's trying to be kind of get at with that language there.
Well, and also when you have a judicial commission,
Yeah.
that is the court, and the moderator of the commission is the moderator of the court. So I think if you have a BCO 15.1 commission, this language would work. We actually had a situation where there was a question of who's the moderator of the judicial commission. Is the moderator presbytery or the moderator of the commission? And likewise for the clerk. And this was like 2 weeks after I'd been elected clerk. And so I called, I don't know if I called Atlanta or I called Houston, and I said, what do we do? And
Houston,
and
we
he
have a
said,
problem.
yeah, I think it was Houston. And Houston said, well, if it's a commission, you're not the clerk of that commission, so that has nothing to do with you. And I said,
Yeah. Well, but also, I mean, committees and commissions have chairmen and secretaries. They don't have moderators and clerks. So if you use the language
Fair point.
moderator of the court, you're talking about
that's a good
the
point.
moderator of presbytery, the moderator of session. A commission just has a chairman, right? So don't go to Overtures committee and say Mr. Moderator when you mean Mr. Chairman. They're not the same thing. So
That's true.
Thank you for helping me. I was already going to make that mistake, so I appreciate that. He's
All
always
right, well,
looking out for me.
Speaking of mistakes, when we get to when our mistakes are bad enough that we have to get to definite suspension, I think Guy Waters has authored some language here that's helpful. And one of the things I really like about it is that it reminds us that even definite suspension, even these disciplinary censures, are means of grace. What do y'all think? From Mississippi Valley, Overture 15.
yeah, I think it's good.
Yeah, it's clear. It is trying to promote, greater harmony across various paragraphs of Chapter 36, because other censures have, formulaic language that's to be used, and it just seems like a well thought out, well reasoned, relatively minor perfecting of this section of the book.
Well, good enough. Thank you to Guy Waters and the wonderful Mississippi Valley Presbytery. All right, another from Pacific Northwest. BCO 41.3, Overture 23, deals with how you got a 2-track system for references here. What do y'all think of this one? That you can ask the higher court to take the case, or you can say, just give us some manpower and try it at the session level. I think that's a good idea. That way the accused still has 2 levels of appeal. That it's not just whatever General Assembly says is going to be the final.
Yeah, I think as a pastor of a church that has a limited number of elders, I think this is a good addition to have to help smaller churches who may need a helping hand in these kind of cases, to kind of borrow an elder, as it were, for a judicial case.
Yeah. I guess the only thing I would say, and again, I would have to look up 3216 quickly, and I don't have it in front of me. As long as the person who is under this trial would have a right to object to them.
And that's exactly 3216.
Okay,
yes.
yeah. Then I think that's okay. Obviously, I mean, if you're going to object to the additional ruling elders or teaching elders so that a trial can go forth, you're basically saying, I'm willing to give up my extra layer of appeal. So I suppose that's fair. But because, again, the problem becomes, back to preliminary principle, right? Having people stand in judgment over you who you did not elect or you did not vote for. But at the same time, I mean, if the accused in this case is willing to allow those men to do that for the sake of let's continue with the trial, they're obviously not part of the session per se. They're just members of the court on the judicial matter. Then as long as they're okay with it, then I think it could be very helpful, both in allowing a smaller body, at least theoretically, to conduct the trial, but then also to give the layer of appeal. So
I'm wondering, as I was thinking through this, it has the language in Part B, as may seem prudent to the lower court. So I take that to mean that the lower court has to assent to the adding of this ruling or teaching elder. But I'm wondering, is that simply at the beginning of the process, or is this in the middle of the process, or towards the end of the process? So, for example, a church brings on an elder and they find halfway through the process that are hard to work with, or they may not be leaning the way that they would want them to lean in this judgment. Could they remove them from that? Or is this simply just at the initiation of the trial?
I think you're stuck with it. I think he's got to be there for the whole. You can't bring him on halfway through.
Okay.
Right.
Yeah, and with the reference, obviously the lower court has to request it. The higher court can't involve itself in imposing it. So the lower court has to ask for it, and then the higher court has to accede to it. The higher court could say, no, we're not doing that. So both have to be in agreement, and the lower court, part of the reference needs to be, hey, we need 3 extra guys, or 3 to 5, or whatever. That would be part of the request for the reference here on 41.3b.
Well,
at first I didn't like.
Yeah, go ahead. Sorry.
I was going to say, at first I didn't like it because of what you said a little bit ago, Steve, about a member of a church is consenting to these elders ruling over him and being a part of the disciplinary process. And but what they're doing when they're taking the membership question, submit to the government and discipline of the church, they're not submitting to this session. They're submitting to the whole government of the church, which includes the whole BCO. So they're effectively taking they're affirming that I will work within the BCO framework that we have, which is session usually, but we have references. The session could send the whole thing up and the whole thing could be tried by the presbytery. So that objection kind of faded away for me as I think about the nature of that question to new members to become a member of a church. Doesn't just mean I'm submitting to this session, I'm submitting to our whole PCA system.
Yeah. Well, and what I wanted to add was anybody that's on Overtures, in B, where it says, as may seem prudent to the lower court, I'm not really sure I understand what that phrase means now, because before A, it has request. So you can request A or you can request B. So if you've requested B, it sounds like you've already thought it was prudent to add more people. If what they mean by that is you get to you have to agree to the men who were sent, then it should say that. But if that's not what they mean, if they say we ask presbytery, we get who presbytery gives us, then I don't know what as may seem prudent to the Lord. I don't know what that means anymore. You've already made the request. Why would it not seem prudent at some point?
I think it's intended to be the first option. That is, the lower court gets to approve the individual people who are sent. That's my point.
Is it needs to say that explicitly.
I don't like the lower court picking its judges. You should ask presbytery, and presbytery going to send you who presbytery sends. You're going to take them.
Well, it's funny. I read it.
I don't disagree with that either. I'm just saying I don't know what that phrase means now.
It's not very grassroots, BZ.
I read it though, Steve, to say that it's actually the number which may seem prudent to lower court. But now that I'm reading it, I'm just inserting that. So I'm with you. I don't know what it means. There needs to be some change there.
Clarity.
So ask someone on Overtures, would the clarification be to either ask the people who wrote this, what do you mean by that phrase, and actually say it, or would it just be simply to remove that language?
You can amend it however you want.
Either or, yeah.
Pick what you think is best.
If you want to say that the lower court should be able to ask for a particular number, instead of saying additional teaching elders, say a particular number of, something like that, right? There's ways to get around it. I just think as may seem prudent to the lower court is, on the one level, it's either so broad as to mean anything, then it kind of all of a sudden means nothing, or it was intentional for a particular purpose, but because the language is so broad, I don't know what specific prudence the lower court is supposed to be exercising in this particular case. So just clarify or remove. That would be my preference for that. Somebody's typing.
Not I. Well, now I'm typing, but
typing madly.
So, well, I think there's some great potential for this one. I assume Howie Donahoe is the author of this one, as it comes from Pacific Northwest. So, well done, Howie Donahoe. What about Houston Metro? Speaking of Howie Donahoe, one of his friends is probably from the Mod Father himself. What do we think of Overture 29 and a minority decision? I think the main addition here deals with the entire record of the case has to be submitted to the General Assembly, which could be 1,000 pages, right?
I disagree. And I think the most important change here is that it's no longer mailed to the clerk of session of each church, but it's distributed in electronic form and published in the commissioner handbook. I think that's actually the bigger change here, because when this was drafted, we didn't send email communications with the commissioner handbook. It was physical. And so all of this would be physical, and that physical limitation. I mean, imagine sending over 1,000. I don't know the number of our churches. What, 1,700? Is that right? 1,800 churches. I could be way off. Whatever our number of churches, thousands of churches, sending a physical binder of all of this, even just the two proposed decisions, to all of those churches. That's a massive financial cost. That's a massive amount of time and work. And I think that probably affects members of the SJC determining whether they want to actually file a minority report. One has never been filed under this system. And I think it's because you have to physically send copies of everything out. Now, this being electronic makes it a lot easier, and it's much easier to distribute the information necessary. And that's why we can now have a record of a case. And it could be thousands of pages. Yeah, that's right. But it's so easy to do that. You do that with a click of a button. And we don't have that administrative burden that there used to be under the old system, or under the system as it is now. So I like this. I think it's good. And this allows these minority reports to be more reasonably filed. Because to date, it's just very difficult to think about all the practical realities of making this happen. And I do think the change in Section C there from or a third of the entire member of the SJC to a third of those voting on that decision, I think that's a good change. It's very reasonable.
Yeah, my only concern is, I mean, it's a couple of things. First of all, I get the SJC members that I've talked to about this in the past have made comments that even if you read the SJC's report, or even if you read a minority report, that's not the same thing as reading the record of the case and or whatever briefs. The problem, though, is, number one, if it's 1,000 pages, 5% maybe of the assembly is going to read all that.
You think that many?
5%, yeah, 5% might
That's
be
like
high.
100 people.
Yeah.
So it's the SJC who's already read it. That's 24. Plus, you think 76 other guys are going to read that?
Well, let's not get hung up on that.
I know, Ryan, all of your listeners will listen. Will
yeah, it's going to be.
I know that for
all
sure.
100 people who are listening to that. No, it's
My
going to
mom,
be.
I think, is the only listener I have, and she ain't reading it.
Yeah, it's going to be a low number. And so then, but also it doesn't, like, at the SJC level, like, you have to make an affirmation that you read the record of the case before you can sit on the full assembly, or the full commission, rather. Are we going to ask the people of the assembly whether they have or not? Is there any, other than, honesty, honor time, whatever? So I don't know what the benefit of record of the case and all briefs timely filed. I don't know. I just feel like we're setting ourselves up for pretending like we've done something when in the actual case, we're not going to do it. The other thing is that, okay, so you get the record of the case. That is all of the testimony, right? What if this is an incredibly, all of these are, just kind of by their nature, they're incredibly sensitive pieces of information. Now it's all out there electronically. Everybody who's registered for the assembly gets it. I'm not happy about that idea of saying we're just going to present all this super sensitive information out there into the world. I don't like that idea.
I agree. And one thing I was thinking through with this was to change that piece about the record of the case as a whole, because a lot of sensitive information, and people could actually argue the slanderous information, right? If somebody's lying, now we're distributing lies to thousands upon thousands of people. And so I think that is a potential problem. And so one thing that this could be amended to say something to the effect of excerpts from the record of the case as agreed upon by the minority report and the commission, so that they have to come together and say, yeah, we think the testimony from these people is important to include, or we think these documents are important to include for the sake of understanding the context. And so that way the commission and the minority report have to agree what goes in that. And likely that might end up that no record of the case is distributed, which I think, to your point, is okay. But I do think some people will want to see that and go back to the primary sources. So maybe there's, I don't know, it's tricky.
Yeah.
Well, yeah, I'm thankful that we've not had a minority report. Although, if I were the one being judged, I might feel differently.
Right.
Yeah. Well, as you say, like even with this year, like a 12-12 decision, more than enough people for a minority report, but we don't have one. So,
and that would have been a very messy case, I'm sure.
yeah.
Oh, absolutely. And I think the SJC is well aware of that, and they understand what it would mean to put a case like this in front of, thousands of voting commissioners.
Literally thousands of commissioners. And in a case like that, they let the lower, the presbytery decision stand.
And this is truly an extraordinary remedy in an extraordinary case, that a minority would do this. And they understand the weight of that.
Yeah. Well, let's move on. We discussed this one again last week, but I think some of you may want to weigh in who were not here last week. Overture 31, Houston Metro Presbytery. I think we have some dangerous overtures. We have some most needed overtures. Overture 9, I think, is the most needful overture that we have. This one, I think, is the most urgent overture that we have. As soon as you appoint a judicial commission, that commission has so much power, and we have safeguards in our Constitution to prevent a court from acting quickly or hastily or rashly, but a commission can act very quickly. And if a presbytery votes by a 55% margin to indict someone, and then votes by 55% to elect the 6 or 10 members of that commission is now more powerful than the court itself. So I think this is a fix for that. I wonder about amending BCO 15.2 to clarify that among the matters not properly executed by a commission are any action of presbytery session that requires a supermajority. Kind of just expand this to the whole book. That's a mouthful. Sorry, what do you think?
Yeah, I'm sympathetic to what you're saying, Ryan. I mean, 15-2 already envisions that there are certain matters that commissions shouldn't handle. So sentence of 15-2, when the ordination of a minister is committed to a commission, the presbytery itself shall conduct the previous examination. So we already recognize that you shouldn't examine a man for ordination by commission, that's not proper. And whether or not to suspend someone administratively, again, which, how are you confident that, someone's being suspended administratively and not by way of censure and all those other things? This seems like an important matter, a sensitive matter, and it seems like it might be wise to commit this to the whole of presbytery as opposed to simply, 6 guys possibly.
Yeah, I just want to echo that and say I agree completely that this is a very needed fix to the BCO.
So what would you think about this, Ryan, where you have where you could permit a commission to make these kind of 2/3 majority decisions, or take these actions with 2/3, obviously, of the commission takes that, but also if they've been specifically given that authority by a 2/3 vote of the presbytery. So in other words, you appoint a commission, and then after you appoint the commission, you have to have a separate vote on the commission has the authority to exercise the right under 3110, and that motion requires a 2/3 majority of the entire presbytery. Because I just see this as, for presbytery to meet, it's very cumbersome. It takes a long time to get them together. And so if a presbytery does trust their commission, I want to let the commission do it. I think this unnecessarily takes things out from you're talking about this not from a principial point of view, you're talking about this from a parliamentarian point of view, that the parliamentarian numbers may not work out so that actually the commission is not exercising authorities that the presbytery would want to give them. But what if the presbytery does, by 2/3 vote, give them that authority to do that? Would that alleviate your concerns?
That would, but I think, just as we discussed with the record of the case, I think a lot of people aren't going to understand necessarily all the implications. So if that were to be done, I think there should be specific, A, B. The commission has the power to do A, B, C, which should be done anyway. I'm just not a fan of commissions generally, but trials, it is hard to conduct a trial when you got a jury of 30 people, or Tennessee Valley people, it could be 60 or 80.
Yeah. Well, I mean, the two trials at a presbytery that I was involved in Ascension, both of those were before the entire presbytery. And on the one hand, I mean, the benefit of that is, and one of them was done prior to the change that the Judicial Commission changed, where before it had to be voted up or down by presbytery, and the other one was after it. But part of the benefit is, you've got an individual who is a member of this body who is under indictment for, in one sense, serious charges. I mean, we wouldn't have gone to the filing of charges if they weren't serious. And I feel like, just as with the ordination of a man to the office of teaching elder, this is an important part of your work as a presbytery. And that, I think, in one sense, I think part of the problem is that presbyteries are far too quick to give this to a judicial commission, because they don't want to have to go through the hard work that it's going to require. But at the same time, like, if you're going to put a man in jeopardy of losing his, livelihood, even for a period of time, and to say, we haven't heard any of the testimony yet, but we think, based upon the allegations, you should no longer be, filling your role, filling your office for a period of time. And, Lord help you if your church is so small that they can't afford to pay you and get pulpit. I mean, all those issues, all those problems. And then a bunch of men who are willing to accept that those charges say, but I'm too busy to determine whether or not you're guilty of this. I find that to be personally egregious, right? So I don't like commissions for judicial cases at all. Now, they're in our book. We have to allow them. But I think with something like this, to say, if you're going to, prior to determining whether or not you're guilty of these, we're going to tell you you cannot fulfill your office. I think that's something the court as a whole should have to do. That's my opinion. I don't think it should be given, even with an extra vote, to the commission. I think this is serious enough that the court itself should have to take it up, and should have to put their name behind it. We agree that these are serious, and I'll be the first to say, right, there are accusations that are serious enough that I would say, okay, until we figure this out, you should not be filling a pulpit. You should not be distributing the sacraments or conducting marriages, or doing anything really that is there for the office of teaching elder. But I've also seen these almost to be kind of the default action of a commission. Well, you're under charges, so we're gonna remove you from office until we decide whether you're guilty or not. So I understand it's necessity, both of them, the commission and the suspension prior to process or under process. I just feel like they're used far too often, rather than at the with due discretion on the part of the court. So
I think the threshold is too low. I think it should be 75%, and then the escrow account, that if you're going to deprive a man of his livelihood, you need to put it in escrow. Now, if you find him guilty and the General Assembly sustains it, fine. But if they turn it over, you need to give them all that back pay, everything. Defense was, a lot of times this is done punitively, just because they're tired of dealing with the guy. Overture 32. Elevating an indefinite suspension to excommunication. How do you define incorrigible and contumacious?
Look in the mirror, Ryan. Sorry, that was you can edit that out too.
Well, I think like a lot of words in our BCO, the court defines them. The court determines what that is. The court determines what a strong presumption of guilt is based on the facts before it. So I don't know that we can give a bright line rule for what that means. And even if we did, the court would still have to make the judgment for what that is. Certainly, we can look at the definition of what these words mean in the dictionary, but to apply it, the court in its judgment will have to determine what is incorrigible and what's contumacious. So, but yeah, and that's a difficult process.
Well, I think in context, right? I mean, in one sense, somebody's indefinitely suspended from the sacraments because of some sin, right? And you are trying to bring them to an awareness of their sin so you can restore them. And they are incorrigible in the fact that they refuse to do any of the things that are in keeping with repentance, right? So, I mean, that obviously there's still a lot of things in that need to be fine. What are those things that they need to do? But again, I mean, look at the Westminster Shorter Catechism. It describes what repentance unto life is. And if some of those things or all of those things are missing, then it's clear that whatever else they're doing, they're not repenting of the sin that they were found guilty of or that they confessed to. And I like the idea that this cements in our BCO that you do not have to have an entire new trial. I mean, obviously you have to have a hearing, and I think that's fair, right? Because again, they have to have an opportunity to come back and say, no, this is what I have done, I'm trying, or something along those lines, and still has an opportunity for appealing that. But I do believe that this is a good way in the horrible event, like you never want to see this happen, but if a man or a woman is under discipline, they are indefinitely suspended from sacraments, because that's really the only thing you could do with a regular member who you did not find repentant. Then this at least gives you a way to elevate that to excommunication if it is true that they are incorrigible in their repentance or being contumacious in their actions with the session or the court.
That's right. So, Steve, would it be your position that the accused here, the one found guilty and the one who is excommunicated, could appeal from a judgment under this new 36.8, or would it be a complaint that they'd have to file?
That's a good question. I mean, without reading it again, I would say it should be appeal. It shouldn't be complaint. Especially, well, I mean, because you're still in the realm of a judicial matter.
Right.
So, I mean, you can appeal. You can appeal censures. So I would say that if a censure is elevated, it's probably worth, whoever's on Overtures this year, it's probably worth to make that clear.
I agree.
But because that also provides the other layer of protection where an individual is seeking to repent, but maybe not fast enough, or maybe that the court has unreasonable expectations of what that repentance ought to look like, and so they have an opportunity at least to appeal that and have it come under review and control of the
Exactly. And I think that's where I'd love to see a little bit more here about what the hearing consists of and what the requirements are. Does it need to be recorded the way a trial has to be recorded, and those kinds of things? Do they have the right to cross-examine? Do they have the right to call witnesses? I'd love a little bit more there. And CCB talks about that in the report. That there's just not there's some ambiguity here that's going to cause problems down the road if we're not a little bit more clear, at least in my view. I'd like to see some statements of what. I don't think it needs to be a full trial with all of the rights of BCO 32 and so forth in there, but I think it needs to at least state a few things that have to be done during this kind of this kind of hearing. It's almost like a parole hearing in some ways. That's going on, and I think we can, because parole hearing evidentiary requirements are different from a trial evidentiary requirement. So I think we can take some analogy from those things.
Yeah. Do we know if anybody from Houston Metro has received the pushback or whatever, the amendments you want to see, and is working on that, or is that something we should try to do?
Hopefully someone from Houston Metro will watch this podcast.
Yeah, that's good.
Okay.
Yeah.
Is that where your mom lives?
Josh Rieger, if you're watching this podcast, hello.
What do you guys think of this in relation to 39 from Southeast Alabama, which aims at similar ends but slightly different and in different chapters of the book?
Right, because these are basically the two views that came out of the recent SJC case over this issue. And the majority view of the SJC was this, that it did not require de novo trial, but it required a hearing. And then the other view, 39, is the dissent in that case that says, no, you have to have a new trial. You have to establish these as new charges, and you have to prove them as charges. And so I think this is just the war between these two different viewpoints. I think both are legitimate. I definitely agree with what we have from Houston Metro as the better way forward.
I agree.
I was reading 39 from Southeast Alabama as not requiring a new trial, but having a greater threshold for elevating the censure, that of 3/4.
You're right. I was talking about 38 from Southeast Alabama, not 39. You said 39, and then 38 was triggered in my head. And 38 is the one that requires a new case with process to elevate. But you're right, 39 is slightly different.
Right. Okay.
Yes.
Yeah.
Not slightly. It is different.
All right. Well, we're running long, and I promised the moderator of Arizona Presbytery that we would discuss some of these study committee overtures. So we've mentioned 37, 38. 40 seems kind of obvious, just record the trial. 37, ruling elders who are federal judges can also be judges at a session trial now if this passes. Seems pretty obvious. What about the study committee and signaling overtures? Mr. Moderator Walker, which ones do you want to talk about?
Well, I'd be remiss if I didn't bring up the one from our presbytery, which I believe is Overture 3.
Overture dose.
That'd be Trace.
Oh, no, I already have water. Thank you. Here it is, a Christian nationalism. So some Baptists have made some errors in their theology, and now the PCA needs to respond to correct this Baptist error. Which Baptist errors will we not be correcting if we correct this one?
Hopefully all of them at some point. That would be...
Well, that's why I'm glad Baptists are Christians, so that when they get to heaven, they can see we were right.
Yeah. Yeah, I mean, one of the things I want to point out is I think there are 4 or 5 overtures that are asking for this. So I do think... I'm thinking of some of the objections that have been already brought against this. One being that this isn't needed, or that there's study fatigue in the PCA, study committee fatigues in the PCA. But I kind of want to push back on that and say, look, I think a number of our presbyteries disagree with that. I think that that should be heard, that there are enough of our presbyteries who are saying, hey, we think this is an issue that is worthy of our consideration, worthy of our best minds being put together to do it. Another objection I've heard is Christian nationalism is vague, it's nebulous, it's ever-changing, ever-evolving. And in some respects, I do agree with that sentiment, but I don't think that's an argument against the study committee. I think that's...
Isn't that the point?
In favor of it, yeah. Yeah, I think that I would say yes to that, and that's what we're asking for here. That's what we're asking to do here. I find that our study committees offer a lot of help, not only to our presbyteries, but to our churches when they come out. Our one on human sexuality, I think, had some affirmations and denials that were helpful. I know that our particular presbytery uses them in our ordination process, and I think something similar for this issue and others perhaps would be helpful for our presbyteries who are asking for this. So if you can't already tell, I am in favor of this, and I would hope that it was something that we would at least strongly consider as a denomination.
So what about the alternate proposal from the Tennessee Valley Presbytery, where it's maybe trying to make both sides happy? Some who just say we don't need another study committee. There's still a fatigue. I think that is real, but yet okay, we want to address this. Let's have this take the form of a letter or a short paper, and don't call it a study committee because that's going to turn people off immediately. Let's have a group of men come together and do something shorter that may be able to help the church. What is the gentleman from Arizona? What does he think about that?
Yeah, I mean, I think that's better than nothing. So if you were to say we're going to do that or nothing, I'd say okay, let's do that. But I still think that a study committee has a wider scope, has funding behind it that's able to allow men to really dig in and really spend some hard time through this process and studying the issues and coming back with something more robust and more substantial for the betterment of our denomination, our presbyteries, and our local churches. And I don't know if this is true or not, but my perception is that this is kind of an east-west divide in our denomination. Many on the west really find this a big issue, and in Arizona we have, some of the proponents of some of these movements here, and we really could use some help from the guys on the east, as it were, to help us out here. Now, it's not exclusive. I know that the Great Lakes Presbytery is one who's asked for this as well, so it's not a hard and fast east-west kind of thing. But I do think that there would be some benefit for doing a full study committee on this. But again, if this gets voted down and then the other one comes up, I will vote in favor of the letter as well. But again, I do prefer this as the option.
Yeah. But I will say that, study committee fatigue, yes, that's real to a certain degree. I will say there are exceptions that I won't name, but I would say for the most part, our study committee reports are actually really good and usually far better than I expected them to be. Maybe that's my fault. But when you get them, you're like, wow, this is actually pretty good. So in a way, I would say that this might not be a bad way to go. I also usually think that study committees should be left to matters that your average teaching elder and ruling elder couldn't figure out on their own. The best one I think we've ever had was the insider movement, because that was so far outside of anybody's wheelhouse and what they were looking at or paying attention to that, we just didn't know that it was even an issue. And it was in the mission field with our missionaries. But so something along those lines. And the question then becomes, does Christian nationalism fall into the category of where your average teaching and ruling elder couldn't figure this out on their own? And I don't know the answer to that. I know it's a fast-moving, amorphous movement that is, gaining some speed. And so maybe having an opportunity to have, it's not an official statement, but, some sort of centralized, well-thought-out report that looks at this may not be a bad thing. So,
what do you, those of you who are constitutional experts, make of what I understand is the stated clerk's interpretation that since these require $10,000 from the AC, it requires a 2/3 vote of the assembly to adopt them because it requires a change to the AC budget. Do you agree with that interpretation?
I'm not going to comment. I've not researched that issue in preparation for this. I'm stepping out of that one.
Yeah, the only thing I would say is I know the change was instituted so that the AC wasn't put on the hook year after year for figuring out how to fund it. And so it would seem weird to me that the intention of saying in the overture you have to decide how the funding is going to happen, that triggers. I don't think that was the intent of the original change to our VCO number or the RAO number of years ago, that it would trigger a 2/3 vote. So maybe that was unintended consequences. I don't know that that's, again, with Jason, I haven't researched the stated clerk's position on that. I just remember when the change was made that it was it had never been interpreted even in the past, even when the study committee overture said AC has to figure this out, that was a change to the AC's budget. So
Ryan, the line in RAO 9.3, any motion to task the administrative committee with the funding of an ad interim committee through undesignated giving would require the approval of 2/3, and this overture has
Designated.
So it just doesn't seem that this would apply to overture.
Wow, that's a very expensive U and N. Or
what again? If presbyteries wish to support this, or private parties, they may. And the AC is not required to find the money through other means. The AC rather just receives monies that people are willing to donate. So it shouldn't require the 2/3. At least this version, in my judgment, shouldn't.
Yeah. Or reallocate from something else that they've already raised money for them. So
I wanted to circle back quickly to the study fatigue kind of sentiment that's going around, and I'd ask my senior brothers here on the podcast. When was the last time we approved a study committee? Because since I've been a teaching elder, we have not done that.
Well, that DASA report, and then
Which was when? When did we not when did the deliverance report? When did we vote?
We heard its report from that lady in Birmingham, which was 2021, and then so that would have been 2 years before that. Was it 2019 that we approved the DASA? And then there was the sexuality report, which we heard.
Yeah, I think it was 2019. It was the year before COVID.
Yeah. So Birmingham was 2022, wasn't it? Because St. Louis was 21.
Yeah.
So it's been 6 years since we voted to put together a study committee.
So now we're ready for a sabbatical for study committees.
So I would just say at some point, it may not be now, but at some point, the study fatigue argument will need to be put to rest and say, we have had enough time passed, and let's do some work that's going to help our churches.
Do you find that fatiguing, would you say?
I find that argument fatiguing, yes.
Yeah, and I think that's fair. I would say it's probably a reflection of the to vote for a study committee requires a high burden of proof. It's not something that people want to do lightly. And I think that comment, that argument is simply a reflection of the fact that, man, this is a hard thing to pull a trigger on because we know it's a big deal. And is this worth pulling that trigger on? So I think it's probably a reflection of that more than it is a fatigue. But the fatigue is real because there is a sense of, these are heavy things and we don't want to just do it on anything and everything. And so that's ultimately the question for the assembly to decide does this rise to that level? Is this worth pursuing?
Yeah, well, and I will say that there definitely was a time when study committee fatigue was a real thing, where like every year there were 4 or 5 coming up, and you'd have we didn't pass most of those, but I think even there the fatigue was less from committees that were in progress as it was everything. We needed a study committee about everything every year. Yeah. There were many of them, so it wasn't even the passing of them and the going through them. It was the
sifting through them,
the requests, year after year after year. So.
Yeah, I think unsolicited advice for someone who's on the Overtures committee. Right now, reading this overture, I don't think I would support it because, as a few of you have said, Christian nationalism is somewhat fast-moving, somewhat amorphous. I'd be much more interested in knowing or having a study committee that, looks into, historic American Presbyterian opinions, writings, practices on the relationship between the church and the magistrate. So what is sort of the secondary element of this proposal? Further, the committee shall advise on whether these viewpoints and formulations are in conformity with our system of doctrine. I'd much rather hear, what have we done over the past 300 years on this topic so that we're not, studying a few books on Christian nationalism that 3 years from now are no longer the main books that people are reading or talking about, or people who sort of fall off because a new person, a new leader, guru emerges in the Christian nationalist space. So that's what
new beard, if you will.
Maybe, yes. So that's what I would like to see if this were to, be modified in Overtures, because I think this is one of those things, can the average teaching elder look into, or will the average teaching elder or ruling elder look into, various writings from the 1900s or 1800s or 1700s on, the relationship between our church, our continuing church, and the magistrate? I'm not so sure.
And I think you're talking, what you're saying there, Stephen, is exactly what 48 is saying on the pastoral letter. It's on the applying the doctrine of the Constitution of the PCA to questions of Christian citizenship and church-state relations for the edification of the church. So I think as far as substance, you're talking about really what they said in 48, not what some of the other ones have brought up.
But I think what Steve said about our committees producing good reports and often being, chosen very well by the moderator. I'd really like to have, the best 10 guys or 7 guys in the denomination sit down and write something more thorough than a letter and then not be funded for it.
Yeah, I would not be opposed to your kind of removing the first part of this. If that's what Overtures decides to do, I would still vote in favor of it. But I would give just a little pushback and say I don't think that it has to be either or. I think it can be both and. And I think that there is a cultural moment that is now, and that's the only time we can speak on it is now. We can't speak on it in 5 years because we're not there yet. So I do think that there are some individuals and some books and some podcasts that are worth us at least looking at now, and then doing something like what you suggested that might have a more long-term lasting value. One's more of like an acute, and the one is a prolonged kind of approach to this. And I think that we could do both.
All right. Well, we've got about 90 seconds left. We've got an overture from PD Presbytery about by faith. We've got overtures from Northwest Georgia Presbytery. And I've grouped all of these just signaling. I don't think any of them have much of a chance, but sometimes just to get it in the commissioner handbook is a victory. Maybe they will. Maybe I'll be wrong. I love it when I'm wrong. Another one from Northwest Georgia Presbytery, dealing with personnel at Mission North America and possible crimes that may or may not have been committed. I'm not a lawyer, but one of you is. Anything else? Final thoughts before we wrap up.
I'm thankful that we give attention to these details of process. I know oftentimes people glaze over them and they don't enjoy talking about them at the assembly level, but it's really important. These things affect lives, and this is shepherding and caring for the flock. It really is. And if we think of it less than that, then we're not going to give it the due that we should be giving it. So I'm thankful for you elevating these things and bringing these to people's attention, because they are important and people need to think through them and think, is this how we should care for the Church of Jesus Christ? Even under the minutest of details regarding process, they're still important, and we want to do it for the glory of Christ and His church.
Amen.
Very, very well said. Yes, and I appreciate you all coming on to talk about these. These are issues that are difficult to consider, especially for those of us who aren't dealing with judicial process very often. So thank you for sharing your expertise.
Happy to.
Yeah, joy to be with
Whatever
you guys.
it is.
Yeah, always fun.
Thanks for having us.
Thanks for joining the conversation on the Westminster Standard, which is the podcast of Jude 3. For more information or to support our work at promoting confessional renewal within the Presbyterian Church in America, please visit our website, jude3pca.org. Join us again next time. I'll talk to you then.